But I was also informed by the community that they want to talk about wills and trusts. It's a very important topic, something we don't want to think about because that deals with when you go away from this world. Stuart, okay, sorry. So this is a very important topic, but a lot of us just ignore it, don't want to deal with it, don't want to talk about it, but you can't ignore it. There are two reasons at least that I can give you. There are many others. One is we're living in a non-Muslim country. If you die without a will, at least, the state laws will determine what happens to your wealth. So if you want to know, you want to determine how this is going to be distributed, better have at least a will. Trust is another topic. Hopefully she will cover more of that. But you need to have at least a will. Even in Quran, we are told to have a will. So it's a fard, it's a requirement. I'm just going to read you an ayah from Surah Baqarah. كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا الوصية للوالدين والأقربين بالمعروف حقا على المتقين. Very simple. It is enjoined upon you when death approaches. So Allah subhanahu wa ta'ala is giving you time until the death approaches. You don't have to wait till then. Any one of you and he leaves any wealth that must be bequeathed for the parents and the nearest of the kin in the approved manner, being an obligation on the for God forgiving, for fearing. So we need to know that there is a farida and it has to be done. And like I said, we don't need to wait till near death. It should be done anytime. Now, there are many ayahs and hadiths which cover this topic, but only thing I want to mention is the ruling should be understood in the light of Surah Nisa, which has like at least 3 ayahs that I know, which describes the entire process, who gets what, boys get what, girls get what, and wives get what, husbands get what, and if somebody doesn't have any children, who gets that? So all that has been described, and people have written books, which is always I say Quran is so detailed. It's like in 3 ayahs, Allah subhanahu wa ta'ala explained the whole topic of how to distribute wealth. We're not going to go into fiqh issues and those kind of questions. That is another something when you are preparing your will, you can look into that. But at least we want you to know the importance. And Sister Sidra, I talked to her. She is an expert. This is what she does, is prepare people's wills and estate plans and so on. So I really appreciate joining. Appreciate all the people who were concerned and joined it. There are some people who had asked me to streamline it, to video stream it, and I hope it's happening. They say when you start speaking, we'll have that. There are people, I don't even know, some of the people are in like Chicago, Wisconsin, I don't know wherever they are. They were sending me messages to send us the link, so I sent it to them. I hope they can benefit from the program. With that, I will stop here. We will have some questions and answer. Either she will handle it, something I can handle, I'll try to do that. With that, you're on.
Is my mic working? Can everybody hear me?
Yeah.
Okay. Assalamu alaikum. Thank you so much for having me here today. It's an important topic, and I'm really happy to be able to discuss it with you all. Brother Aslam asked me to talk a little bit about wills and trusts, the difference between the two, and how I use them in my practice. I am not an expert in Islamic inheritance laws, but I have been following, especially in the last couple of years, what scholars and attorneys have been talking about and working together to find a way to incorporate Islamic inheritance rules and into estate planning in the United States. So I've been exclusively practicing in this area for 7+ years, like I mentioned, and so Brother Aslam conveyed to us how important it is to create a will and as Muslims to have an estate plan. Currently, there are about maybe 35 to 40% of families in the United States that have an estate plan. And I think it's even lower when we're talking about just Muslim families. And that's interesting because the concept of death is it's so integrated in our religion. And it's something that we are told that we should constantly be thinking about and contemplating our death and striving to find a balance between the akhirah and dunya. And so we should be thinking about death and planning for our death. It is half of our religion, but it's also a taboo subject, like Brother Aslam mentioned. It's something that we don't want to think about. I think the younger generation often ignores the fact that, or it's not something that younger generation really thinks about. It doesn't apply to them. There's a feeling of immortality that it's not going to happen to us, so it's not something we want to think about at this time. I think the older generation, I have clients that come to my office, and that they want to create an estate plan for their families, but they don't want to disrespect their parents by bringing up the concept of death. So this is something, as a Muslim, as our ummah, we need to kind of get over that fact, the uncomfortableness of talking about this subject and having that conversation, and being open with our families when we talk about dying and death and our plan when we pass away. So the concept of death is uncomfortable, and I think the concept of money is also very uncomfortable in our community. Like discussing it openly with our families, as far as wealth goes, planning goes. Our first generation Muslims, the parents of first generation Muslims, they came to this country not really having much. I mean, there were exceptions, but some families were able to transfer their wealth from where they came from to this country. But generally speaking, our immigrant families came here with very little. And so the preservation of wealth was not at the forefront of their thoughts. It wasn't a priority for them. As first generation Muslims, second generation Muslims, we're in this country, we're thinking more about generational like wealth management and generational wealth, how to use the tools that are provided to us in this country, and how to create a plan for our families so that we can catch up to those communities who have in this country who have been using and thinking about this for a lot longer. And so we have to be comfortable with talking about death. We have to be comfortable with talking about money. But it's also really important to have these conversations because of the mandates that are in our religion. The Quran has predetermined shares very clearly written out in Surah Nisa, as Brother Aslam mentioned. There are areas of our religion where they may be gray areas or differences of opinion, and where we can bring into our religion the interpretation of what's been told to us. But inheritance and rules of inheritance isn't one of those areas where we can bring in much interpretation of the rules. The fractions that are given to us are pretty clear cut. It is what it is, the 1/8, 1/6, 1/4, sons inherit double the amount as daughters. Those are all very clearly defined in the Quran. And so we as a Muslim community, when we say we don't really want to follow those rules, we're entering into a dangerous territory where we're bringing in our own ideas of how we would want to structure or the rules that we would want to follow in Islam. And I think that can be it can be harmful to our ummah. If we're already struggling with living in a secular society, and so we should really, those rules that have been given to us in the Quran, we should be comfortable with following those rules and understanding them and learning them. And when Surah Nisa was revealed at the time of the Prophet ﷺ, it was a very different family structure. The family was more of a domestic, extended family situation where brothers and uncles and sons, they were in charge of the wealth. They were in charge of taking care of the women in society. As now it's not necessarily the case. We have more of an emphasis on the nuclear family. Women are bringing wealth into the family. Women are controlling the finances in the family. So the family structure is changing. And then often also, I think spouses rely on the other spouse to take care of finances for their children. And it's no longer the case where you would rely on your father to take care of the grandchildren in the family. And so I have a lot of Muslim clients who come to me, and maybe I would say 50% of the Muslim clients that come to me, they are not interested in creating an Islamic estate plan. They specifically tell me that they don't want to incorporate Islamic percentages in their estate plan. And I think the concern for those Muslim families is generally that they want their daughters to inherit as much as their sons are inheriting. And they want their spouse to have more than their 12% that they would inherit. And so the question then is, how do we reconcile the desire to treat our children equally, to be able to leave enough for our spouse to be able to take care of themselves, and but also implementing our Quranic responsibilities, and then while also taking into account the modern family structure. And this is when we say Islamic estate planning, that's what we're talking about. The ongoing conversation that's happening right now between attorneys and scholars, they're working together to come up with a solution to that question, an answer to that question on how to best incorporate Islamic estate planning inheritance principles, how to incorporate Islamic principles into estate planning. So there are multiple ways of achieving that goal. To give you a little bit of basic information about wills and trusts, a will it's a vehicle that you can use to transfer your assets to your beneficiaries. It's a document that has two parts. One is writing it down. The second is probating it. Probate is the process. It's a court process. You submit the will to the court. The court validates the authenticity of the will, and then assigns the executor that you choose in your will to manage the distribution of your assets according to terms of the will. You are able to write in Islamic principles into the will as far as distribution goes, the percentages that we talked about. But it is limiting in the way that you can't necessarily instruct your beneficiaries on how they should use that wealth. So we talked about inheritance and the fractions that go with inheritance, but we also need to take into account that Sharia inheritance laws and rules are not just those fractions. There are legal obligations to the people who are inheriting more to take care of those who are inheriting less. So writing into our plan a way for those people who are inheriting more to be able to use their inheritance to take care of those who are inheriting less. That's something we wouldn't be able to do in a will alone, because the beneficiary receives something outright, and there's no instructing that beneficiary on how to use those funds. And that's why most of my clients who say they want to do Islamic estate planning, I recommend writing a trust. And it scares people away when I say trust. They think expensive, they think it's complicated, but it really works in the same way as a will does. It's a vehicle that is used to transfer your assets. You choose a fiduciary similar to a will. In the will, it is the executor. In a trust, it's a trustee. The trustee is then responsible for distributing the assets according to the terms of the trust. The difference between the will and the trust, and the benefit of a trust, is then we can now dictate what the beneficiaries can do with that inheritance. And that's really beneficial as a Muslim and trying to incorporate Islamic principles, where we can write into the terms of the trust that that the trustee has discretion, has the ability to seek out counsel from someone who's familiar with Islamic inheritance rules, who can seek out counsel from a scholar or sheikh or imam who would be able to help with distribution of assets in an Islamic way. It safeguards what we want to do, while also making sure that the beneficiaries who are receiving the inheritance, they are using that inheritance to help those who are not receiving as much of an Islamic their share of Islamic inheritance. So we can write that, we can dictate it as far as what they need to do with distribution. Trust is also effective immediately. You would not need to go through probate court for it to be effective immediately. When you pass away, the trustee has immediate authority to access funds and be able to use those funds. Whereas in a will, you don't have that the immediate ability to access the funds. You do have to go through probate and then transfer those funds. So the will is one vehicle. There are other benefits to a trust that I won't go into since we're talking specifically about Islamic estate planning, but in general, it's central management of your assets. It's if you have a trust, you don't have to worry about probating in another state if you have out-of-state property. There are some privacy benefits to having a trust, and then there is some creditor protection for your beneficiaries when you have a trust. And if anyone has questions, they can ask me about that. That's not to say that every family has to have a trust. There are situations where it depends on the family and the heirs and the family, whether there are 3 sons or 2 sons or 1 daughter and 2 sons, like that. If it is an easy family situation where you can get away with giving equal distribution to all of the sons and those are the only heirs, then maybe you can get away with just having beneficiary designations to your assets, or you can write the percentages in your will. But again, with the will, it's in Islam, in the Sharia, it's those Islamic inheritance rules only apply when you pass away. And when you're writing your will, you don't necessarily know who will predecease you or who will be the heirs at the time when you pass away. So you're writing the will. Those percentages may not apply at the time when you pass away. And when you have a trust, you have the trustee who would have the ability to change the percentages outside of the courts, and not have to worry about going through the court for permission or the ability to change the beneficiaries is a lot easier in the trust. So you can do it by will, you can do it by trust, and there are one of the easiest ways is to come up with a family plan of how you want to use your inheritance, and oftentimes you can accomplish that by having waivers from the family members of their Islamic shares. So Islam, again, it only comes into play when you pass away. Anything prior to your death, you can distribute as you want, in any way you want. And so if you are concerned about your daughter receiving less than your sons or your wife not receiving as much, then you're able to come up with a plan where your son is willing to waive his additional inheritance for the benefit of whoever else it is in the family that you want to write into the plan. But then there's also a question of coercion. I mean, parents asking their sons to do this, and it is their Islamic right to have their inheritance. And so what I do usually in my plan is I still.
Battery died or something.
Yeah, I think the battery died. Okay. So to alleviate that, I write into my plan the ability to take back that waiver or the consent at any point, if even at the time of death, that a person who has waived their Islamic right, they can always take it back, so that there is no question that there was any sort of coercion in signing these waivers, or they only signed it because of guilt or pressure from their family. And then finally, so there's wills, trust, there's coming up with a plan, waivers, and then there's also gifting beforehand. If you want to gift the assets that you own to someone, and you feel like your daughter would be better able to manage your business assets or any other assets that you prefer one of your children to have over the other, you can always gift it in your lifetime. And Islamic inheritance, I think you can't do it if you are on your deathbed or if you have a terminal illness, but you can do it at any point beforehand. So it is important to have these conversations with your family members. Gifting also comes with some tax consequences, so you should definitely reach out to a lawyer and an accountant to make sure that what you're doing doesn't have any adverse consequences. But it is an option. And another reason why that's a good option is because there are studies that have been done that say that the optimal age of receiving an inheritance is between the ages of 25 and 30, but the people who receive inheritance are around the ages, like typically around the age of 55, 60. So gifting and planning ahead of time, it can be very beneficial to your family, it's just more useful if you were able to plan ahead and be able to give it at an age where it would be more useful to your family members. One of the first questions that we always ask also in Islamic estate planning is who owns what. I think that's a question that that can be difficult, and that's where a lot of the interpretation comes in, as far as if the spouses own 50-50, or if the husband is bringing in more money, how much of that is the wife entitled to. I think only recently in this country have they valued a housewife, have given a valuation of their services and their contribution to the family and how much that is. And some people also, they think that the only reason why the one spouse is able to bring in that income is because the other spouse is supporting them and enabling them to be able to bring in the income. So it's important to label what it is that you own and what your spouse owns, because then those percentages will mean something entirely different. Because if you're saying, well, my husband has all of this, but my wife only gets 1/8 of what he's bringing in, it's a lot less than if you say, well, he owns only 50% of everything that we have, and then we're talking about 1/8 of that 50%. I guess another thing I wanted to quickly mention is that the concern about Islamic estate planning, Islamic inheritance rules, a lot of people think that it's not fair to women. But then I think that's when you forget that the legal obligation that goes with the men's inheritance, whereas there is no obligation for the women and their inheritance to take care of anybody else or to use their inheritance for any other purpose besides whatever it is that they would want. So it's really, and if you think about it, at the Prophet's time, Prophet ﷺ, it was very unique to give women the right to be able to own or have any sort of inheritance. So really, I think that fairness issue, if you look at it, it's not, if you really think about the numbers and the reasoning behind it, and you look at it to see that obligation of men, that they have to use their inheritance to take care of women, it's still pretty friendly towards women. So I guess just to keep in mind, knowing that this is something that we need to take care of in our Muslim communities, keeping in mind what is instructed to us in the Quran, sitting down with our families and having these conversations and discussions openly. cultivating the trust within the family. It really, these rules are there for preservation of family, and it's not. And in the end, we want to avoid the fighting and any sort of issues that would arise from having to talk about money. Defining what it is that a husband owns and a wife owns, and then memorializing all of these, everything that we would want to incorporate in an Islamic an estate plan, and using the tools that are available to us. And just if you talk about it beforehand, there's no surprise, and you're better prepared for death, and then you feel more comfortable knowing that you're leaving your family in a better place. So when we're talking about Islamic estate planning, that's generally what we're talking about. It's not necessarily that you have to, your son gets more than your daughter, when you pass away, you're giving, this is what you get. It's more about raising our children to understand why our religion mandates what it mandates, and then using the tools that are available to us in this country to accomplish those goals. So that's pretty much all I had.
Jazakallah khair, very important topic. One thing that I picked out that a lot of people question is why daughters get less. It's a very complicated question. And one thing she mentioned is very important to know that this is when you are gone. So all your life, if you think any of your children need more than the other one, regardless if they're male or female, you can give them, help them out buying a house, buying a car, or anything you can do in your lifetime. You can give anything you want to anybody within, even people who normally won't get anything. Like you have a cousin or uncle or aunt who normally would not get anything, and they're very needy, they're living overseas, very poor. Give them in your lifetime if you can afford to. And that, there are all these things that are available to us. And also one more point in Islamic law, you can give 1/3 of your wealth to anything, to a charity, to whatever. This is beyond the 2/3 gets distributed. Almost all of 100% can get distributed. But you have the freedom to take 1/3 of that and give it to any cause. And actually, the will kits that are around by ISGH or ISNA, they recommend, of course, to write that in your will to give it to ISNA or ISGH. But you can give it to your favorite charity or a person that normally won't get anything. It can be distributed. You want to talk a little bit more about trust?
Sure.
From my understanding is trust is again, you can do a lot with it, and it doesn't go through probate in the court, directly. Is that correct?
Right. It's effective immediately. As soon as you sign it, it's effective.
Okay.
The way I explain a trust is if you think of it as a box, and you're putting everything that you own into that box, and then you're giving it to someone else and telling them, I want you to be in charge of everything that I've placed in this box for the benefit of these people. It's a third person taking care of your assets for you for the benefit of somebody else. And you can write into the trust anything that you want, any terms that you want. You want to distribute it out at age 20, 21. Even when our kids turn 18, they're not financially responsible enough to handle a large amount of money. You create that trust and you put it into the terms of the trust that I don't want my child to have access to these funds until age 25, except that the trustee can use them for health, education, maintenance, and support of my child. But that trustee doesn't always need to distribute it out to the child at all. In fact, it could stay in trust, and then they could distribute it out to the institutions that the child needs, like for education purposes, or if they have hospital bills. The trustee can then pay out directly to those institutions, and that way the money is never in the hands of that child or the minor or the 21-year-old. I always say you never know at age 21 if your child wants to enter into some sort of, a dead-end investment opportunity, or they get married at a young age, and then, God forbid, they get divorced, the ex-husband or ex-wife is now a creditor of yours, and they can come after you for all the assets that you own. So keeping it in a trust protects it from those creditors. If they're in a situation where they may get sued, or someone is coming after them for whatever reason it is, having that money in a trust protects those beneficiaries from those creditors. So yeah, it's a really good tool to be able to write in whatever instructions that you would want to give after you pass away, how you would want your children to use the inheritance that they're receiving. And you don't want their money or your money to be their primary source of income. You want it to be something that will keep them comfortable, that they can use when needed. But you also want them to know that there is a responsibility of still working hard and making money, and not using just like a trust fund to get by.
Very good point. Correct me if I'm wrong. The way one time it was explained to me is trust is like an artificial person you created, and trust doesn't die unless you kill it. I mean, it's like we all have limited life. Trust can go on the way you design it, and the wealth can be distributed through a trust. And and trust in Arabic is called waqf, and waqf concept has been around Islamic civilization for all the time that we've existed. So it's very well tested. It's reviewed by all scholars, all four schools of thought. They have fatwas on it, that how the Islamic trust works. And again, a lawyer will prepare it for you. Usually a Sharia scholar will review it and make sure that it's all in line with Sharia. And that's, again, if you have a lot of assets, at least have a simple will that will take care of things. But as your assets grow, I think trust is the right direction. It's a little complicated, but it can be done.
Well, the way I explain it also is that, a trust is just a piece of paper, right? Until we actually move assets into the trust. So you need to have whatever assets you have, a bank account, retirement account, any investment accounts. You need to contact those companies and make sure that the trust is the beneficiary of those accounts. That way, everything flows directly into the trust, and then it goes based on the terms of the trust that you laid out in your plan. But if you don't put anything into the trust, it's really just it's a very expensive piece of paper, right? But also, like your house as well, you have to redeed that property so that the beneficiary of the home is the trust. So yeah, it's a vehicle. It's very useful, and it's not just for people who have a lot of money. I think that again, I recommend it to all families that have minor children. I recommend it to all families that want to do Islamic estate planning because of the ease of management of the assets. Yes.
Very good. I'm sure there will be questions. I see if you want to.
Question. So, like I said, the will can be probated, but the trust cannot be probated.
The trust is not probated. It's effective as soon as you sign it. But again, it's not. It won't mean anything until you transfer those assets. So when you pass away, your successor trustee then takes the trust document to these companies, lets them know that these original trustees, which would be, you who are creating your estate plan, you would be the original trustee of the trust. When you pass away, then whoever it is that you name as your successor trustee, they would have the ability to access those funds in those accounts.
So what if the trustee passed away before you?
Yeah.
They can be able to change it to like a living trust?
It is a revocable living trust, and you can revoke it at any time during your life, and you can amend it as needed. But you should also have alternate trustees. You can have co-trustees. The only time that gets complicated is when you need both trustees to sign off on something, and maybe there's a disagreement, or they don't agree on what to use those funds for. If they want to invest it in one thing and someone disagrees with that investment choice, then it can get a little bit complicated if you have co-trustees. But it is something that some people do.
Okay, Javed.
Yes. Are there any tax benefits for a trust? Because there is inheritance tax.
Yeah.
If you have a will, you will pay the inheritance tax also. I mean, after a certain amount. Are there any benefits of trust that you don't have to pay this tax?
So currently, the tax exemption amount is $12.5 million. And that's for one person. As a married couple, you have almost $25 million of an exemption amount. The way I explain that is that if you have $13 million and that you are now paying 40% in estate tax on that $1 million that's above the exemption amount, right? And if the exemption amount is at 12 million. So people want to avoid that 40% tax on that amount, right? If you have more than that, but it's not something that most families have to deal with. But when you are dealing with it, then it becomes a little bit more complicated tax planning, and you wouldn't be able to get that tax benefit from a revocable living trust. You can look into maybe doing irrevocable trusts, but again, that becomes complicated. You would have to have a third-party trustee. It has to leave your hands and come outside of your estate. To take it outside of your estate, you would create these vehicles. They're irrevocable living trusts. It's something you would not be able to revoke in your lifetime. And a lot of people don't want that, and they don't want to lose control of their assets either. Putting those assets into an irrevocable trust, the corporate trustee or someone that you would designate to take control of those funds, they would have investment choices, and you would be able to get distributions from that, but you wouldn't be able to change it in your lifetime. And so not everyone they don't want to do that kind of complicated tax planning. The exemption amount is set to sunset in 2025 back to 5 million. So if we're now talking about like 10 million in your state, then you can start thinking about tax planning again. But a state, we don't really know what's going to happen. It depends on who the president is or whatever the laws are at the time, as far as that exemption amount going up and down. But we don't foresee it going any less than 10 million.
Okay. Any question from sister side? Okay. Yes, go ahead.
In your inheritance, the distribution is fixed for the heirs. Like these are 2/3, or it will be the whole amount. You can't change that. Provided, what you mentioned, if there's a waiver, And it should be distributed right at the time of your passing away. So if you have a trust, can you leave that one in there and not violate the inheritance law?
So that's a really good question, and I think it's a complicated answer, because that is what scholars and attorneys are kind of trying to figure out. And the solution to that some of these scholars are coming up with is creating a court system for just Muslims in the United States to be able to handle questions like that. Because I don't think as an attorney I'm qualified to answer that question. And I don't think that even one scholar can give a fatwa and say, okay, well, our religion says that we can do that. We can leave it in a trust and it's okay. It's not going to violate what Allah has told us to do, we can leave it in a trust, I think, like legally, if I work it out, like what I would think, we would be able to leave it in a trust as long as that person who is entitled, who has that right, has access to it. That I think is permissible. And it's not taking away from their, their legal, Islamically legal right to that inheritance. So I think that you can keep it in a trust, but as far as putting restrictions on it, I don't know if I think most scholars would agree that you wouldn't be able to do that, as far as like not allowing them to be able to take it out of the trust. But there are other rules in Islam that say that you don't give inheritance until the person is financially responsible or able to take care of that, that amount of money. So I think those kind of rules that we put into the trust, saying that at a certain age they're entitled to make decisions for themselves, they can become co-trustees of the trust. I think that is allowed, but I can't say for sure. That's something that maybe an Islamic scholar would be able to better answer.
So how these trusts is applicable to 401ks and IRAs Yeah. For example, we have retirement account
Mm-hmm.
in your financial institution. Moment to do it, they may be something like
Mhm.
beneficiaries and contingent beneficiaries.
Mhm.
So will that be carried over into the trust, or we have to tell them now that we no longer primary beneficiaries, we have to be the trustee? That's how it works.
That's exactly right. You have your retirement accounts. These are non-probate assets. They have beneficiary designations, so they pass outside of probate. So even if you did not have a trust, whoever you designate as your beneficiary in those accounts, they would receive it without having to ever go through probate to receive those assets. Once you sign the trust and it becomes effective, you reach out to these companies and you ask them for those beneficiary forms, and you put the name of the trust as the beneficiary. Yeah.
Yes? Go ahead.
What's the meaning of estate? What does it include?
Yeah, that's a good question. That's a really good question. Estate is all of the assets that you own put together, minus funeral costs, minus final medical bills, minus any debts that you have, and anything that is left is the residuary estate that is distributed according to whatever plan you have written out. So all your assets.
In the trust will just include estate. That will include everything then?
Yes, in the trust, how I write it is that we take, the trustee has the obligation to pay the debts prior to any sort of distribution. And then the trustee gathers everything that you own. And you can say that out of my estate, I want 1/3 to go, 1/4 to go, whatever it is, whatever those fractions are. But if you have specific distributions in mind, like if you want to use your retirement account to pay off the house or whatever it is, then you mention something in broader terms other than just estate, right? And in the trust, you also have a schedule of assets at the end of the document that lays out all of the assets that you plan to put into the trust. And that's important because then the successor trustee knows what assets that they're dealing with and what assets that they need to transfer over to the beneficiaries. So you do have a schedule of assets that you wouldn't just say estate, you would say what all those assets that are included in your estate.
So if you want to define it estate, you have to list all the assets.
If you want to define the estate, not necessarily. Even if you don't list it, it's still part of what you own. If you legally own something, it's part of your estate, whether you write it down or you don't.
So you don't prepare any document.
Well, the document would be the will or the trust, and that document would be what you would use to be able to legally transfer from your name to the next person who owns it. Because if you own a house with your wife and you pass away, your wife owns it, but in this country, she wouldn't own 100% of that house. She would only own that 50% of the house, and you would still have to go through probate to clear title and to say that, okay, now my wife is the heir of my estate, and then she now should have 100% of that house. Does that make sense?
I'm getting some online questions, so let me,
Yes. You can have as many trusts as you like, and you can have just one for the family. Mhm. Yes, and with my trust, we still have what's called pour-over wills. So we still do the will because, like I was mentioning earlier, if you don't retitle your assets, then they're not in the trust. And so you would still need to go through probate to transfer the assets from into the trust. So we still do wills, and it's just a safeguard that you have in place so that if you acquire more assets in the future, you'd be able to, and you forget to label it into the trust or transfer it into the trust, then you'd still be able to transfer it from the will to the trust. That's a good question. Overseas properties do not, the laws of this country do not apply to any property outside of this country. So you would, if you want overseas property, if you want to take care of that through estate planning, you need to make sure you have a lawyer overseas that will help you do that.
Yes.
It sounds like, from the whole discussion, that the trust supersedes the will. So, the will is an injunction from our religion, that needs to put in place. Is it possible to specify in the trust that the will will supersede the trust?
It depends on the asset that you're talking about and how you label that asset. If you're transferring that asset into the trust by adding it to a beneficiary form, you're taking it outside of probate, and the trust would supersede the will. If you don't want that asset in the trust, you don't label it in the trust. And most they don't conflict really with each other. Like, your will should be working together with your trust. So if there were an asset that you wanted specific instructions for, you write it into the trust that this is this asset, and this is what I would want to happen to this asset. Like, they should work together. They should not be conflicting.
Brother in the back, yes, please.
For spouses, you have two wills?
It is highly recommended to have your own will. Each spouse should have their own will, because when we probate the wills, you have to submit the will to court, and you no longer have control of that will. So practitioners now only create wills for each individual. They don't do couples wills.
Okay. Yeah.
So I guess from this discussion, it looks to me that if you have reasonable assets, then maybe the trust is the way to go. So just for the benefit of everybody, what are the approximate costs of setting up a trust? And how much are the recurring charges or annual charges for a trust?
That's a good question. I should defer that to my husband, because he says I'm really bad about talking about these facts.
I would recommend you talk to any lawyer if you want to go to her. There are many people who do that. Each one has different charges. It also depends upon the asset size, what you're dealing with, the complications. I've heard numbers from $2,500 to $10,000. Just all depends what you're dealing with. There's no
And
stick.
honestly, that was what the range I was going to say.
What I'm saying is that IELTS level, we are looking at this thing for the community, for the benefit of the community, and we just want to see, what is the best we can do, at the lowest cost for the community. So just to give them an idea of it.
We'll talk about that later.
No, but I do think that that's generally, with the time that goes into the trust, with the expertise that goes into creating the trust while following the laws of this Texas, ensuring that we are following the rules. If you talk to any attorney, it'll probably, at the lower end, will be around 2,500 to maybe 6 to 7. It really just depends on what your asset size is and what you're looking to get out of it.
Brother Aslam, yeah.
Along that line,
Let's start with you. Okay, go ahead.
along those lines, if somebody wants to decide whether will only or trust, of course, we need to talk to you. So on the first, and based on the asset volume, you would be able to give an approximate cost at that time, I would assume.
Yes, if you come to me, I would definitely be able to give you approximate cost.
Now, the follow-up question is that the first consultation to determine that what's required, what needs to be done, how much the cost would be? Is there any charge for it, or is that the first consultation is?
That depends on the attorney that you're talking to. Some attorneys give free consultations, some attorneys don't. For me specifically, I waive the consultation if you hire me. So if you end up hiring me, then there is no consultation fee.
Okay, so the first one is basically, it could cost if you don't hire me.
Yes.
Okay. Got a question there? Yeah.
I had a question.
First of all, Michelle, well, thanks for your expertise and all this information here. What is your opinion on those online will and what things that they have? Do you think that they do a good job, or do you think it would be better to kind of consult with an attorney?
That's a really good question. Online wills are not state specific. There are certain nuances to Texas laws that require specific language that should be included in wills. I've seen some of these more popular online wills that they're very generic. They will not name family members and the percentage that they receive. Again, I don't think there's any such thing as an online trust. And I think when we're talking about Islamic estate planning, I really do think that the trust is the better way to go. But of course, it depends on the family. But these online, I think lawyers, they like them because it ends up making them more money in the long run, because there's always some mistakes. And so you will have to go through probate, and there's a missing witness signature. It wasn't notarized, and so they need to go through additional proceedings in court to make it self-proved. And there are just some requirements, like as if you have an attorney, that the attorney can tell you the consequences of what you're doing. And if you're going online, you're not going to have someone telling you, that this is what you did and this will suffice according to the laws of your state. So I would say avoid. People make mistakes, especially the fill in the blank wills. And there's always something missing. If you don't have two witnesses, it is not a valid will. Even if you say, this is my will. But there's, holographic wills, which is a will that's written in entirely your own handwriting. Those are considered valid wills in Texas. But again, that'll require more work in probate court, like more court costs and attorney's fees in proving up that sort of will. At the very least, write it down. Like if you don't have anything else, if you don't want to pay money to an attorney to help you get it, just do what you can and have something. It's better than nothing. But if you have the option, I would say avoid those online forms and talk to a lawyer.
Your sister in the back, yeah.
No, you do not. You do not need to have your house paid off to list it in a trust. Your mortgage would transfer to whoever it is that you're transferring the home to. If you're transferring it into a trust immediately, you may have to reapply for some exemptions, like the homestead exemption, or if you are a senior citizen and you're getting a senior citizen exemption, then you may have to you may not get that if you transfer it into trust. But the way that I do it, I have the trust as beneficiary, so it's only the trust only owns the home when you pass away.
Okay, I have some couple of online questions. They're very simple questions. One is, what is the difference between revocable and irrevocable trust? Just quickly.
Yeah, sure. Revocable trust, you can tear it up and change your mind as you wish. And irrevocable trust is not, you have a third-party trustee taking care of your assets, and it's not something that you can easily change your mind. I mean, there are ways to go to court and change the terms of an irrevocable trust, but again, becomes complicated.
So is that correct, that you need to file a separate tax return for irrevocable trust?
That's
And like a EIN number from IRS? That's
Yep.
another thing.
That is correct.
Revocable doesn't require that. Another quick question, is can a person specify to look after our children in case of our death before they reach adulthood in the trust? Can you specify in the trust who will take care of minor children until they are able to receive the inheritance?
Yes. So guardianship. That's going into guardianship law, and we definitely in the will I specify who the guardians are. In the trust I specify who the guardians are, and then I have a separate form that will state who the guardian of your minor children would be. In Texas, we have guardianship of the person and guardianship of the estate. So you can usually have the same person be that, but you would have to go through both guardianships in probate court. If someone has to take control of your minor child. Guardianship of the person is taking, who houses the child, who gets to make daily decisions. Guardianship of the state is the person who is in charge of the finances of the child. Now, if you have a trust, you don't need a guardianship of the estate, and it's another reason why we say have a trust for if you have minor children. Also, it avoids the guardianship of the estate is a lengthy process, and they're very strict about who's able to be guardian, and then you have yearly accounting requirements.
One more.
Yeah.
It's the last question, I hope, because we need to wrap up anyway.
So then you would have to go through the guardianship proceedings, and whoever steps up, whoever steps up to say, I want control of the child, the court will look into the best interest of that child. If they're over 12, then they can ask the child's opinion. But yes, if you don't have guardianship paperwork for your child, then the court gets to decide what is in the best interest of the child. And even if you have guardianship paperwork, the court still looks into what is the best interest of the child. So if you have it, but it highly emphasizes what the parent wants, right? Like they will look into that, and it's an important part of their consideration as far as what parents would want for their child.
Okay, I think at that point, we're gonna wrap up. I think she can probably answer one or two. You can just reach to you, give a few more minutes to just hang around.
Yeah, sure.
Yeah, just ask her directly. We need to wrap up. There is probably pizza outside, and if you wanna grab that.
Is your handwritten will is accepted by Texas?
Yes, it's a will entirely in your own handwriting, stating that this is my will, dated and signed, is accepted in Texas, but it requires additional steps in probate to authenticate the will. So you would have to bring in handwriting experts to or witnesses that are not interested in your estate to testify as to the signature on the will, that that they are familiar with it, how they're familiar with it. They have to go to court. It's just additional costs and time consuming.
Okay. Say that again.
Your handwritten will with two witnesses.
Yes. If you have two witnesses and notarized, then it's a self-proved will, and it would be accepted as a will, valid will.
Okay, Jazakallah khair. If you have more questions, you need to buy her time and go visit her office. But I think it was very useful. Jazakallah khair. Okay. Our director is asking for a.
Okay, I have some cards I can pass out. If you
Okay, yeah, there was an online question too, so I'll write that back to them. Okay, Jazakallah khair for making the time this late in the evening and a weekend night. Jazakallah khair, all of y'all. I hope you are more aware of this importance and try to practice what needed to be done. قولي قولي هذا استغفر الله لي ولكم.